Hello, good evening.
Good evening. Good evening, Jaspreet, and good evening, everybody. Welcome to the third webinar hosted by the Singapore Chamber of Maritime Arbitration in joint conjunction with the Institute of Chartered Brokers, ICS Singapore branch. I'm Puneet Oza, the Executive Director of SCMA and the moderator for today's session. This is a special one for SCMA as well as for myself, as this is the first webinar which is jointly hosted with the Institute of Chartered Brokers Singapore branch, an organization with which I am also involved as the vice chairman. ICS represents commercial shipping professionals around the world, and this is thus a very ideal collaboration, especially on this topic. Let me start with a few administrative announcements. The webinar is being recorded and is also being streamed live on the SCMA YouTube channel. This also means that you can access this webinar at a later date at your leisure on SCMA YouTube channel. As you scroll your mouse on the bottom of your screen, you will see a Q&A button. And in the Q&A button is the place where you can access any questions. You can actually ask any questions. We will have hopefully around 30 minutes towards the end of the webinar for your Q&A. I will be able to ask these questions to any or all the panel members as they are directed. Coming to the subject, the topic today is arbitration should not be a death knell for business relationships. Is this too utopian a statement? Is it even possible? We will hopefully hear from the experts soon on this topic. But before that, can we actually have a quick poll to get the audience's view on this particular subject so that we can try and see if we can compare audience's view having whether it has changed towards the end of the seminar. So the poll is actually already there. Do you think that commencing arbitration against your counterparty will adversely affect your business relationships? The poll is going to be open for another half a minute, I would say 30 seconds. It gives you a flavor or gives us a flavor, and as well when we talk about sharing this results, it's quite interesting to see how that will work out. There's actually a fairly mixed bag, but the yes seems to be winning at the moment. So another 20 seconds. And then we should be, yeah, we will end the polling. So the results are 62% of the audience believe that it does adversely affect business relationship when you commence arbitration against your counterparty. 21% believe no, it doesn't, and 17% are not sure. So the polling is closed. Sorry, I'll just press the button. Yeah, and that's the poll for you. So carrying on effectively, as I said, let me also state from the SCMA's point of view that whatever the eventual conclusion, this is an amazing opportunity for SCMA and all of us to learn what could be the possible ways to improve, highlight, and focus on those aspects of arbitration and its processes to make it a commercially acceptable process to resolve disputes. To arbitrate or not to arbitrate, that is the question facing any commercial decision makers. There is a perception among the commercial maritime community, as I said, as you can see from the poll, that commencing arbitration means the end of relationship. Is this a correct perception or a misconception? This is the discussion we're going to have today. At SCMA, we truly believe that arbitration's image needs a positive reinforcement. And in this webinar, we wish to explore the idea that commercial disputes are a part and parcel of any business, and if resolved through arbitration in a cost-effective, efficient, and fair manner, they can actually help parties achieve closure on their disputes and move on with the future business dealings with each other. Done in this manner, it smoothens the path for business while leveling some of the bumps on the road in form of disputes. And I'm so pleased that we have an amazing panel here to discuss this topic. Firstly, representing a ship owner, we have Jamie McBain, Mr. Jamie McBain, who's a director at Oldendorff, Singapore, and he's an SCMA Local Users Council member. Welcome, Jamie. Jamie started his 26-year-old shipping career in commercial shipping as a shipbroker with Howard Holder and Clarksons, and then moved on to working with various ship owners and operators such as Armada in Australia, Clavness in Singapore, where we worked together for a few years, Golden Ocean, Singapore, and now Oldendorff, Singapore. In one of our discussions, it was he who came up with this very statement, which forms our topic today. So I look forward to hearing your views, Jamie, and I'm sure so do the audience. Secondly, representing a cargo owner is Captain Jaspreet Chabra, who heads global freight operations at Louis Dreyfus, and who's also an ICS Singapore EXCO member. Jaspreet's seagoing career spanned from 1975 to 1988 with Tolani Shipping, where he then graduated from an apprentice to a captain and thereafter joined the same company ashore on the commercial side. He has since worked with Cargill, Valencia Exim, and now Louis Dreyfus. He brings a blend of both technical and commercial perspectives and experience to this discussion. Welcome, Jaspreet. I'm sure the audience and me look forward to hearing your views.
Thank you, Puneet.
Next, representing the lawyers, Mr. John Simpson, who's a partner at Stevenson Harwood and also an SCMA board member. John started his career in 1999 with Ince & Co., where he joined as a trainee solicitor, eventually moved to a position of managing partner. He's now with Stevenson Harwood as a partner. He will be able to give us a perspective of what arbitration means to the counsel and what advice do they give to their clients when it comes to arbitration and the proceedings. Welcome, John. I'm sure we look forward to your views as well.
Thanks very much, Puneet.
Finally, representing the arbitrator community and completing the picture is Mr. Prem Gurbani from Gurbani & Co., who's an independent arbitrator. He started as a pupil and later associate of late Justice of Appeal M. Karthigesu from 1977 to 1980, and later was a partner in Netto Law and Partners and a founding partner of Gurbani & Co. He became a consultant on 1st November 2012 and is a panel arbitrator of SCMA and various other arbitration institutions, and is also a board member of Singapore Maritime Foundation. I've had the pleasure of interacting with him on various forums since 2012, and his commercial and legal perspectives are quite original and useful. So welcome, Prem. I look forward to your discussion as well.
Thank you.
I finally have the pleasure to introduce Captain Subhangshu Dutt, who's the current chairman of ICS Singapore branch. I've known Captain Dutt since the last 14 years, and I've had the pleasure of working closely with him at the ICS Singapore branch. Captain Dutt is a seasoned maritime professional who came ashore from a seagoing career in 1988 and joined PIL and then moved on to various positions such as running Pacific Shipping Trust and representing Krishnapatnam Port, and is now currently having his own company, Home Maritime. His amazing experience is just the right foundation to set the tone for this discussion, and I would like to invite him to present the opening remarks. Captain Dutt, please.
Yeah, thank you, Puneet. Thanks for the good introduction and very impressive panel we have here. So when Puneet asked me that the Institute jointly hosts this webinar, I was absolutely delighted. You know, there is so much of commonality between the Institute and SCMA at least on this topic. And the Institute itself, for those of you who are not familiar, it's a 110-year-old body established in 1911, and primary role is to deliver education, which is where the common ground exists. We deliver education, commercial education in commercial shipping, and which focuses on knowledge, on professionalism, and if you think a bit deeply, this is where we have a slight divergence from SCMA's objectives, because the more knowledge and professionalism that you apply in constructing your charter parties, in constructing the various clauses, these will help you to avoid getting into an arbitration situation. So that is where we try and explain to our members, to our students particularly. So that's the value that we are giving you. So having said that, yes, it's not a perfect world, and invariably differences of opinion and disputes would arise, which would lead to arbitration. And I'm one of the ones who voted against in the poll, because I genuinely believe that there should not have been any intent to get into a dispute. It happened in the course of business, so it should not affect business relationship. In a perfect world, owner and charterer could be discussing a new fixture, and at the same time, maybe something which happened 3 or 4 voyages back is on the arbitration table, So that is something which could happen and is likely to happen. So it'll be interesting to particularly look at some arbitration cases which happened in the early days of COVID. When there was no clarity on the direction and on the consequences. Of course, since then, many customized COVID clauses are being incorporated to charter parties. Some of them are so complex that you would need a set of arbitrators to interpret them as well, So that is how developments are taking place. But yes, I won't take too much of airtime on this. I am looking forward to a very interesting discussion amongst the panelists. So with that, thank you and a good discussion, and I hand you back to Punit.
Thank you so much, Captain Dutt. Thank you very, very much. And I would like to set the ball rolling. We've already had a poll now with regard to most of the participants and attendees do believe that the commencement of an arbitration does actually damage the relationships between your counterparty and yourself. So can I start with Jamie and then Jaspreet with their own specific experience as to what has been their experience with regard to this particular aspect? Have they seen this happen in real life? What have been the alternatives to actually commencing the arbitration, and have they actually been the right decisions economically as well as strategically? So shedding a bit of light on the practical aspects will be quite useful to start the discussion, Jamie. If I can start with you. Yeah.
Sure. Thank you, Punit. Afternoon, everyone. I think from a commercial perspective, if two parties have to go to arbitration, it's generally viewed that we've exhausted all other reasonable lines of discussion. That includes commercial settlements, which generally are not in favor, or there's always going to be one side that feels that they're a little bit hard done by on the, from taking that sort of view. But often it's viewed again that it's probably the most commercial and reasonable conclusion to make, even though it might not be legally the right decision. Excuse me, one second. Sorry about that, working from home. As I was saying, yeah, I mean, more often than not, from my experience, arbitration hasn't been the path of choice. Generally, a settlement is the way that we go, and quite often it's just not the right one. I would just like to touch on something that Captain Dutt said. If you have a well-crafted charter party, and then you should never have to get to the point of having to take it down a legal road. But that does rely on two things. One, having skill set to actually craft a decent charter party in the first place, which is a discussion for another day. And secondly, having both parties willing to adhere to the terms of the charter party. And more often than not these days, charter parties, we deal with quite arbitrary people, more often than not, who tend to treat charter parties maybe as an option rather than as a means of recourse to settling an issue. With that in mind, it's inevitable that if you cannot use a charter party to reach a resolution, then and a settlement is just not going to come about, then arbitration is your option. with the arbitrary nature of a lot of people that you deal with in this industry, and let's not forget, it's not an exact science. People don't go into business deals hoping that it's going to end in this way. But the perception of arbitration is that it's a costly affair, both in terms of time, effort, inconvenience, which ultimately leads to the financial costs. It becomes a bluffing game. One side might very well take the opinion that, we can just keep burying our head in the sand. We cannot answer these requests for settlement. We cannot take the discussions any further, because they won't go to arbitration, because it just takes up too much time and it costs too much money. If a viable alternative was in place where you could get a timely settlement and the costs involved were a lot less, and again, this is a perception thing, it might not actually always be the case, I think it would be a tool that we would go to much earlier on in the piece, which would inevitably bring the issue of damaging a relationship. It would probably take that off the table, because don't forget, there are layers of a relationship. Generally, deals are done between two individuals representing their companies. Now, up to a point, generally those guys quite often are friends, and they can come to reasonable solutions. Maybe I'll take one this time, and and we work out a way of squaring the ledger somewhere down the line. If you move towards an arbitration, it then becomes a company versus company situation. And bear in mind, the decision makers in this process, when it gets to that point, they're not legal practitioners. They quite often, if it moves to a senior management level, they're not even that au fait with what's gone on up until that point. It purely becomes a commercial decision. And at that point, everyone's backs are up a little bit, and we know there's no winners. And it's daft to expect that there are. I mean, this is the whole point of a ruling. But from my experience as well, even if you win an arbitration, you still end up losing. You don't recover all your fees. You spent an inordinate amount of money. The time spent on it just doesn't work. So I think in its current form, with the current perception of arbitration being literally the last resort, it does have a damaging effect for sure.
Sure. Absolutely. So you touched on a lot of practical points that you probably go through in day-to-day life. Jaspreet, if you can also elaborate from your side, and what has been your experience with regard to how have you actually been resolving disputes, and when is it that arbitration becomes like the go-to solution compared to being the number one solution to being the number last solution kind of a thing?
Thanks, Puneet, and thanks for Captain Dutt and Jimmy. I do agree with both, because you see, the word arbitration brings a person to a point where he feels that, yes, in spite of all efforts have been put up, we are not able to reach to a conclusion. Now, there are two ways of it. You see, as Jimmy also said, that there has to be some skilled person involved in this. Quite often what happens in a company, even on the commercial side also, people are, two parties or two individuals keep talking, and then suddenly they feel, oh, yeah, we are not reaching to a point, and it is passed to higher up. Now, it all depends. The person whom we are passing, is he competent enough? I'm not saying that the position what he's holding, I'm saying the competent enough means he know all the charter party terms. He's very well known to all these new clauses, like Captain Dutt said, now, because we have so many DIMCO clauses, we are facing a lot of crew change clauses. Now, when you land up into these type of clauses, it is better to resolve amicably and then say, oh no, I have spent so much money. Just a simple case. Vessel had armed guards on board. Suddenly rules changed that they cannot be disembarked in so-and-so position. So now owners are saying, oh, look, this is not my fault. So who will bear those expenses? Because those expenses are going to be too much. So if two parties can come to a table and really go through it and really see that, this could have been, it is nobody's fault. It has just happened due to the environment changes, circumstances, and we should agree to it. So these type of things, if it can be handled, but if we pass to higher up, what most of the companies are doing it, they're passing to external lawyers. No, or they're P&I clubs. P&I clubs in terms of they hire another external lawyers. So expenses keeps going up. When expenses goes and the end of the day, what Jimmy said, even you win, you have lost it because you are not satisfied that how I am going to recover my legal fees, which is, or I have spent so much time. It's not only the fee I'm talking about the time. So if in my opinion, yes, charter parties, if somebody can do it, well and good. Otherwise, the relationship has to be perfect. I mean, they should not feel it. We are going to arbitration. The arbitration could be a different, starting a different level, because in an MNC, you have so many offices, and you have one owner who has given you 7 ships. I'm talking the charter's point of view, and
Sure.
one ship has a problem, and 6 ships are doing fantastic. But that one ship, which is under different entity of that MNC in different country, they
Right.
want to go for arbitration. So these things, we have to wait very diplomatically. Communication has to be clear. Skill sets have to be top notch. And then, yes, of course, the word arbitration it doesn't sound well, but I am firm believer that even you go in arbitration, you are going to deal with the same owners. You are going to, meet them anywhere, and you meet them again. But you cannot keep in your mind that, this ship we had a problem, and this owner or this charter never paid, unless something has drastically goes wrong. So I think if SCMA comes in, it will help a lot to ease up the tension. Over.
Sure. Thank you, Captain Jaspreet. This was a very good start. If I can just take away the main points from what the discussion so far has been, is about the fact that arbitration sits with an image of being expensive, time consuming, and also damaging relationships. So can I just take you back a little bit, Zing? In the Asian context, settling issues or settling disputes is a very old age concept. The court system is fairly recent in terms of post-colonial age. So obviously people were always going and talking to or asking one of the wise men to come and resolve their disputes because you had different points of view. So the key that we actually try to grasp here is, of course, to make the process more efficient, streamlined, cost effective. Obviously, all of this SCMA is striving to do, but it's also the mindset of the parties that I really find interesting to discuss when it comes to what is it that they are looking for. Are they looking to resolve their disputes and move on, or are they actually trying to gain on each other and score points? So sometimes the distinction between the two becomes fairly blurred, and then it becomes a personal kind of a fight against another company or another individual, and that can be, of course, putting a shade of a different kind on how the arbitration is perceived. So the perception is what definitely is what I've come across in my own commercial side, is that if you are able to explain saying that this is a dispute too big for you to resolve, too big for me to resolve, because both of us have different points of view, let's go to a person who is a subject matter expert and let us give his decision. And that should be the right approach going forward. That doesn't mean that this person, like Jamie mentioned, who's a part of a social circle that you always catch up with, is going to be any different because tomorrow morning he's got a case against you on arbitration. So this is the kind of probably the premise on which we are starting this off as a discussion. But if I can take this forward and to the next level and maybe get John here, saying, do you actually agree with the perception of the arbitration which exists today when discussed from what Jamie and Jaspreet just told about? Is that the perception which most commercial parties have? And how often have you actually advocated settlement knowing well that the case is still something where the parties who are going to settle, one of them will actually lose out in the bargain, and he may have a strong case, but you still believe arbitration is not the way forward because reputational challenges, relationship challenges do exist. So what is it from a lawyer's perspective, if I can ask you, John?
Thanks very much indeed, Puneet, and thank you also to Jamie and Jaspreet. The perspectives which both Jamie and Jaspreet gave are very much the perspectives which clients of mine would also give. There is definitely a perception of arbitration as being expensive and time consuming. And it's not just the time and expense that's spent on lawyers, it's the time which the client side have to spend in getting documents together. So it is a situation which people do not want to get into, but sometimes there is no other choice because a resolution needs to be reached. One thing that I wanted to start off by saying is that whether or not the arbitration will harm the relationship between the parties, in my view, very much depends on the size and the type of the dispute. If you have a bet the company type arbitration, where if you don't win, you're going to go bust, those are always acrimonious. It would be very unusual where you have a situation that is that big for the company, which does not end in difficulties. And I really think that it would be very hard to find a way around it. So the kind of arbitration which I think we are focusing our attention on here is the kind of dispute which is the everyday knockabout type dispute that you get in the shipping business. We had a discussion beforehand, and as everybody in the panel today recognized, shipping is a risky business. There are plenty of risks to undertake. There's all sorts of unknown factors and things go wrong. And I think everybody in the industry has grown up enough to realize that things go wrong sometimes, and that you can't, with the best will in the world, you can't draft a clause for every single situation in your charter party. I'm constantly giving presentations about new clauses that you could put into your charter party in order to deal with new situations which have arisen. And as I think it was Jaspreet who pointed out that there are constantly new, excuse me, sorry, my other phone is ringing. One of my colleagues is at court at the moment on a matter which is not arbitration. Sorry, as I was halfway through saying, yeah, the BIMCO is also constantly producing new clauses to deal with the new situations that happen. And if your situation happens before the new clause comes out, then you have to deal with it one way or another on the basis of the agreement you've got. And it is then up to the parties and the lawyers to sort out the issues. In terms of expense, I agree fully with what both Jamie and Jaspreet said, that even if you win, then often you end up feeling that you have spent a considerable amount of money, and in the ordinary course of things, you will recover 60 to 70% of your legal costs from the other side if they are able to pay. There are methods in arbitration to get you to a point where you can get most of those legal costs back. You can get security for costs, for example, at a certain stage in the proceedings if it looks as though the claimant is not going to be in a position to pay your costs if you win. But that may not be enough comfort. The thing about arbitration, though, and the thing which I thought was worth getting across in this forum, is that it is and should be different from court proceedings. A lot of arbitration agreements and institutions are such that they are really mini court proceedings, but in circumstances where you just get to choose the judge effectively. Each of the parties can appoint an arbitrator who has experience of the particular commercial issues which they're looking at. And one of the most important things which I do when asked to commence arbitration proceedings is have a very careful look at which arbitrator I'm going to appoint on behalf of my client, because there may be particular areas of expertise which we think the tribunal will require in order to resolve the dispute. And there may be areas where we think that if the tribunal doesn't have that expertise, they might come to a decision that we don't consider to be correct. And that is something where arbitration does have an advantage over court proceedings, because it gives you the opportunity to choose who decides. The other aspect is that you can look to the rules in arbitration to assist with resolving your dispute in an expeditious manner. And SCMA has the CDOC rules for resolving collision claims quickly, and it's also got a small claims procedure which is meant to resolve matters quickly and cost effectively. There is also a consultation at the moment about changes to the SCMA rules, and I think it's really important that the whole of the community that uses SCMA gives their input into potential changes to the SCMA rules, because those potential changes could and should make arbitration swifter, more efficient, and a way of resolving disputes more cheaply, which I think is probably the principal concern of the two users that we've heard from so far. They want it to be resolved, and they want it to be resolved cost effectively. The final thing which I wanted to say just before I let maybe Prem have his say is that it may be possible as time goes forwards to use technology to a certain extent to reduce the burden. One of the main burdens, which it was either Jamie or Jaspreet mentioned, getting together all the documents for the lawyers takes a lot of time. There is currently a discussion that we are having, it's at a very, very early stage, about possible use of technology to assist parties in getting their documents together for arbitration purposes in order to reduce the burden on them. And actually, Puneet has been fairly central to that, but it's a very early stage, so it's something maybe we can talk about later. But technology could be helpful going forwards.
Thank you so much, John. These are good perspectives in terms of where arbitration benefits. Another thing which I find very useful from a commercial user perspective is the fact that you also do keep these things private and confidential. You get the chance of keeping things as PNC as possible. The other thing, of course, is that I still believe that when the dispute is actually arisen, if it is resolvable quickly by talking to each other, then nothing stops you from doing that. Even when arbitration is already en route or in progress, a lot of the arbitrations do not eventually reach the final stage of award, but they actually get settled on the way as well. So obviously parties must keep talking, and that is obviously the best way to resolve things. But arbitration should not be looked upon as a negative thing, and that is probably where the emphasis is coming. But coming to a perspective from an arbitrator's perspective, Prem, if I can ask you, what is the actual situation on the ground? What role do you actually play as an arbitrator to actually keep it fair and commercial? And how can parties walk away from arbitration actually feeling that maybe we didn't win or lose, but we got a fair hearing and a commercially viable solution from which we can now move on to the next business, so as to speak? I mean, a closure of sorts, if I can say, that arbitration is able to provide. So what do you think from an arbitrator's perspective and arbitrator's idea on this matter especially?
Thank you all. Looking at the topic, what I see is, if I can just put it in other words,
sure,
it just means, can we remain friends?
Yes.
Can we remain friends? By the time you have come to a decision that you need a determination of your rights and you're unable to settle by other means, say mediation or something of that sort, you really have only two alternatives. You have either arbitration or you have the option of going to court. Of course, you need to go to arbitration if you're required to go to arbitration by your charter party. The similarities between court proceedings and arbitrations are simply that both proceedings determine your rights and result in an enforceable award or a judgment. But then there's absolutely no doubt that an arbitration is a far less formal process. If you do want to remain friends, an arbitration is a far less formal process than going to court. I mean, those of us who have been counsel in courts, I've been practicing in the courts for more than 40 years, will tell you that the stress that the parties suffer as a result of being in court, of requiring to be in the witness stand for days on end, and facing all the formalities that the judges and the courts impose on you, those things don't exist entirely in an arbitration. They do exist depending on how the parties behave, but it's always up to the arbitrators to control these things. So it is by far a far friendlier process. I do accept that the way that some arbitrations are conducted nowadays resemble court proceedings. They tend to be too formal. But again, that depends on the role of the arbitrator and how he conducts his proceedings and how he disciplines the parties. Sad to say, sometimes the parties' lawyers need to be disciplined as well. So it can be a very informal process. There is also, unlike in court, the option of a documents-only arbitration, which is quite a common thing. We are talking about maritime arbitration. And a documents-only arbitration is really the norm in most maritime arbitrations. Although there is a provision that in the SCMA rules that says, look, you need to have a hearing unless both parties agree. I think that rule is being looked into, and there's a recommendation that that rule be changed to give the tribunal the discretion as to whether there should be such a hearing.
Yes, there is actually a recommendation of sort, and hopefully the public consultation will cement that thing, Prem, as well. Yeah.
Yes, and the other thing that parties often forget, as far as dispute resolution is concerned, is the rules of evidence. I mean, if you go into a Singapore court, it's not as if you're going into an English court. We don't have a Civil Evidence Act. So you have to prove your documents by a number of archaic rules, which we have inherited some decades ago from codes that were adopted from India. So you can get into a real mess if you do not handle the proving of documents in court in the right way. Let me give you a war story to illustrate this.
Sure.
I was once involved as counsel for an insurer in a claim made by a party who had lost a set of risers used on a drill ship. Those risers had been reconditioned in Singapore, but they were reconditioned negligently, as a result of which the drill ship went into the Bay of Bengal and lost its entire riser stack. The claim was about $21 million, right? So there was a fight on liability. As you imagine, there was, whether or not the work was done negligently was a matter of expert evidence. And then, of course, liability, and then the next issue is quantum. The claimant succeeded in liability, but as far as quantum was concerned, the claimant succeeded for only $1 million. Why? Because the claimant couldn't prove the documents in respect to the balance of the claim. Now, looking at it from an arbitrator's point of view, that difficulty would not have arisen in an arbitration, because the Evidence Act of Singapore specifically says that the rules of evidence in the Evidence Act do not apply to arbitrations. So it would have made a tremendous difference, having regard to the finding that there was, that the claimant succeeded in liability. It would have made a tremendous difference if that had gone on to arbitration. Bringing me back to the original point, which is it would have been a far friendlier process.
Sure.
Yeah. So
just to add into what Prem has just said, it's not just that story. There was I'm not a Singapore lawyer, but there was a recent decision, World Fuel Services, a month or two ago, where the claimant was asked to prove the authenticity of the documents, and they didn't call the necessary witnesses to attest to their signatures. And it seems to me, reading the judgment, that the claimant only lost on that basis alone, and probably might have done, the result might have been completely different if it weren't for that.
exactly. So these are things that make the process friendlier. As I see the topic, is it a friendlier process than going elsewhere? Right?
Yep.
Can I just add something there? I think, 100% agree with what Prem's just saying. I would just like to add, I personally would like to see the option to go to arbitration be taken much earlier in the process. But for that to happen, the perception has to change. It has to become cost effective. There has to be a reasonably quick ruling made. I think if we can get it to that point where it becomes a tool, a commercial tool for us to use, rather than
Jamie, if I may interject here.
Yep.
So coming back to the point that was made, you have to choose your arbitrators carefully.
Sure, but
there are interactive. There are arbitrators that are interventionists almost, if I can use that word, and there are arbitrators who let the parties control the proceedings. So if you choose your arbitrator depending on his personality and the way he normally conducts his proceedings, which the parties will know, then there's no reason the arbitration proceedings cannot move along at a regular pace.
On the assumption that, as I said earlier, though, that the decision to go to arbitration is made by people who are au fait with the process and the arbitrators involved, which is generally the legal department or outside counsel. What we're trying to achieve is not getting to that point and having people like myself choose to go to arbitration very early on in the piece, because we trust the process, we trust the practitioners, we assume that it is going to be a fair and equitable way of dealing with an issue and moving on. I mean, don't get me wrong, I'm all for it. I think it's, for me, having arbitration as a tool that I can turn to much more quickly in the proceedings is only a good thing. But as it stands at the moment, the general perception is that it's the big bad wolf at the end of the line kind of thing. If you have two parties that share this view, then it's not going to be an issue. But
or
generally,
if we are able to popularize this view, if we are able to put this view out there, raise the awareness quotient of the value that arbitration can bring at an early stage, obviously that will help as well. Yeah. But I just have one quick question, which is from one of our panel arbitrator of SCMA, Karina Albers. She's saying, it sounds to me that so far the desire for early neutral evaluation is a preferred form of dissolving disputes. So John and Prem, maybe you can give a quick reaction to this. Is early neutral evaluation by the arbitrators could be a kind of a two-tier process, where eventually the second tier is arbitration, but the first tier is this early neutral evaluation? If you can just
if I may take that first, there is no provision in the SCMA rules for neutral evaluation. The arbitrator is required to look at the submissions, if necessary, hear the parties, and then issue an award. And that is it. A neutral evaluation is not something that is in the SCMA rules. And well, if you call an award a neutral evaluation, then that's it. Neither is there, but in the way that the words neutral evaluation are used, and the courts here often go into neutral evaluation, they have come up with something new. It's not a common procedure that's used in arbitration, in maritime arbitrations, certainly as I know it.
Unless the parties decide to
Yes,
do
of
that,
course.
because
The parties are of course completely the masters of their proceedings. So if they decide to have a neutral evaluation and turn up and say, look, I've got this problem, and he says this and I say that, can you tell me what I should do? And that's it. I mean, take an example. My first arbitration as a young man who had just joined the bar was in Liverpool. It involved a shipment of cotton. They called it an arbitration, but I think what they really have in mind in those, is a neutral evaluation. So I took a plane to Liverpool, which I was delighted about because I've always been a Liverpool Football Club supporter.
right, well done.
So I was delighted about it. I flew down to Liverpool. We went down to the docks. We went down and we saw thousands of bales of cotton. The arbitrator took out his penknife. He had accompanied the both of us. He took out his penknife. He went around and said, I want this and that and this and that bale. So he picked out about 10 randomly. He cut open the bales. This is a quality dispute. And then looked and smelled the stuff, took out a pad and wrote his decision. He says, this is it. I'll get it typed out later, and that's it. Right. From then, that's 1977. From then, we have moved to a position where things have got more and more formal. Not so much in maritime circles, I must emphasize, not so much in maritime circles, but in other international arbitrations where the arbitrations rooms resemble war rooms. But in maritime circles, we still have some of the ethos that used to exist in the old days.
Right.
We still have a certain sense of informality that used to exist in the whole old days.
I agree with you, Mr. Prem, because we do have sometimes cases where we says, okay, which arbitrator are you going to appoint? And sometimes yes, we trust as a person, both party agrees. So those things are still happening, but as you said, yes, it's no more that easy.
It's not a perfect science, and parties obviously get angry with each other and so forth. But if there is a process where you have a chance to remain friends, I come back to my remain friends, it is certainly arbitration.
Agreed.
It's certainly arbitration. Yeah. So
absolutely. John, sorry, go ahead. Go ahead, Prem, sorry.
So as for now, the point has been made, I think, that too much money is involved. Too much money is involved. It is true that in some arbitrations, too much money is involved, but there is a large body of disputes out there in maritime circles which involve actually not that much money. Of course, there are the major cases, but most of these cases are demurrage cases and small claims of between $100,000 to $500,000. A lot of them can be resolved by the adoption of the small claims procedures that exist in the SCMA rules. And if you adopt the small claims procedures, there is no oral hearing. The decision is a summary decision. Costs are controlled to a certain fixed sum as far as the winning party is concerned, and a fixed sum for the arbitrator as well. Correct. So there is the bulk of the disputes. You are able to control costs. And I think the figure at the moment in the SCMA rules is 150,000 for small claims procedures, but it's soon going to be raised, I believe, to what is it now, Puneet?
The possible raising to $400,000 is what we're talking about.
So at $400,000, you're going to get a lot of the disputes going under the small claims procedure. I would venture to say at least half of the references that start in the SMA will probably land up under the small claims procedures, which means you know exactly what you're going to be paying. Doesn't matter how much you pay your lawyer. Talking about lawyers, the other thing that's not commonly appreciated is amongst the users in Singapore is that you don't need a lawyer. You just need an arbitrator. You just need to write a submission and send it to him. And so does your opponent. And if you like, you can ask to turn up before him and say your piece.
What does
You
John think about that?
Yeah,
I think John will have his.
you can say your piece in whatever manner you want, right? And in any business, give it any business slant that you want. It's the arbitrator's job to go and sort out, right, the arguments as far as the law is concerned and put it and give his decision in accordance with the law and the facts. So you don't really need a lawyer. And that brings us to the point also that has been made that P&I clubs nowadays use in-house lawyers. They use their own lawyers. They don't use external lawyers. P&I clubs nowadays, especially in Singapore, have in-house lawyers that do all these things.
Absolutely, but I would love to get John's views, of course, on the early neutral evaluation, but also on whether lawyers are needed in an arbitration case in the first place.
Absolutely no. You don't need. For instance, I still have a practicing certificate because once in a while someone says to me, look, can you go and argue this for me in court? So I keep my practicing certificate.
Right.
But if I were to appear only in arbitrations as counsel, only in arbitrations as counsel, I wouldn't need to be a lawyer. I wouldn't need to renew my practicing certificate because anyone is entitled to be there to argue.
From my perspective, I think that there are a lot of very small claims out there which it is completely uneconomic to engage lawyers or indeed anyone else to represent you in order to get them done, because actually not all that much really rides on winning or losing. However, enough to make it worthwhile commencing arbitration and going through a small claims procedure where you know that your costs are capped. So I would agree that there's a certain subset of claims where lawyers are not essential to the whole thing. Prem is obviously a very experienced advocate himself and has been a lawyer for a very long time and is very, very well used to presenting claims on behalf of clients. So not holding a practicing certificate and not being a lawyer are two different things. But once you get to a certain size of dispute, I think it is worth having your point professionally put forward and having a professional advocate argue your case. But I would agree that there are certain lower value claims where perhaps the expense is not merited. And there are some extremely capable in-house lawyers in the P&I clubs who have come from very reputable shipping firms and have an excellent background in it. And often they will handle the documents-only arbitrations themselves. And that is a significant saving on costs for the maritime community. In terms of early neutral evaluation, my view about early neutral evaluation is that if each of the parties is sensibly represented and has lawyers, I have just said that maybe they're not required in every dispute, but if you have a dispute of the requisite size and each party is sensibly represented, the lawyers will very likely pretty much agree on what the law is. Where the disagreement will happen will be about what exactly the facts are and how you apply the law to the facts that exist. And an early neutral evaluation can be a very useful procedure, and it can help the parties settle. And in its natural existence, early neutral evaluation is a non-binding procedure. So it's where both of the parties go on a without prejudice basis and ask somebody they trust, an arbitrator, for example, to give their views on a presented set of facts and maybe even some submissions at a very early stage, and say, well, I think that X is right and Y is wrong. And generally speaking, that is then taken by the parties and used to settle their dispute rather than that being an arbitration award. And there's a very good reason for that not being an arbitration award, and that is that at that point in the proceedings, the parties will not have been forced to disclose their relevant documents. They won't have had an opportunity to get orders for the other party to disclose documents which they think are highly relevant to the matter. They won't have had a chance to cross-examine witnesses and really get to the heart of elements where they think the other party may be withholding some of the facts or not telling the entire truth. And for that reason, an early neutral evaluation serves a purpose, but it shouldn't be your determinative award. I am, however, all in favor of finding ways to sort things out quickly. My clients are always happier when I sort out their issues for them. My favorite situation is where the issue is still developing at the time when my client chooses to instruct me, and then I can form the facts to a certain extent and try to avoid a dispute happening altogether. That is definitely something where I feel I can add real value. But if it does result in a dispute, then one of the things which is very important really is that the lawyers on each side don't fall out with each other, because probably by the time you've got to a significant size of dispute, I know we're talking about carry on disputes without falling out, but quite often the commercial parties will have fallen out with each other, and that's why they've gone to arbitration. It's very important. One of my mentors at an early stage in my career said to me, if your clients can't talk to each other, make sure you can always talk to the lawyer on the other side, because you're doing your client no favors if you get to the point where you can't talk to the lawyer on the other side. And ultimately, your clients engage you to resolve disputes, and they engage arbitrators to resolve disputes as well. And that's the business that we are collectively in, and what we're talking about here. So in summary, really, early neutral evaluation as a tool to resolve disputes, I think, is a great idea. And there are certain disputes where perhaps engaging lawyers is not justified, because the money involved in paying the lawyers might start to get out of control and make the underlying dispute less capable of settlement as a result.
Sure.
Punit, can I just read this from one of the participants?
Yes.
Hariharan.
Yes.
Hari.
VK Hariharan VK, major charterers and owners.
Yes.
That one.
Yes, major charterers and owners are more pragmatic in how they approach arbitration and disputes. That's a good point, because when you have a situation where parties go to arbitration, if you have a major charter or major owner, he just views it as one of those things that you do in business. They tend to treat them as fixture-based individual cases. Unless there is major unethical or serious breach of terms are involved, they don't stop their existing business relationships due to one case or dispute. I absolutely agree. Good point.
Absolutely. And that's a very good point. And there's another point that Pietro makes.
Can I just jump in on that one?
Yeah.
That depends where the balance of power lies. Quite often, from a ship owner's perspective, you do have situations whereby, especially if you're dealing with big companies, where the attitude is not do you know who we are, but it's kind of the undertone is there that if you want to keep doing business with us, you just put this one to bed, and we will do, and we'll do more business with you, but therefore the net result, if you choose not to go down that line, is it's the axe in the relationship, because you're then, and let's face it, there are lots of choices for both charterers and ship owners, I guess. But you know, major charterers, tonnage is not a short supply, and quite often you have to fall on your sword a little bit in an effort to keep doing business. But you know, that's not a great way to do business. I wouldn't suggest it as a model for success. And as I said, the alternative is, you know, you really are taking a chance on whether or not you will continue to do business with these people if you choose to take them on, which is unfortunate.
Yep, and that kind of answers a little bit about the question that somebody else asked. I think it was Su Kun Chua. Would you do business with a party again after going through an arbitration with them? And I presume that would be, again, depends on the balance of power and very much the way people perceive resolving a dispute as being a personal discussion. Yes, Jaspreet, sorry, go ahead.
Yeah, you see, if you recall, I just mentioned in the beginning, I gave example of 7 ships. And if you have dispute on one ship, and that does not mean other ships, they are not performing. But what Jimmy has said, it's very correct. I mean, there has to be some limit. There has to be some sort of, understanding that, okay, we have done this, but in future, these are the things we have to follow, and both have to agree amicable. I mean, it's very easy to say that big charters, big owners, it doesn't matter. Yes, when it comes to overall evaluation, yes, it doesn't matter. But if it is happening quite often, you do serious things, and then everybody knows. Because most of the time, let me correct it, tell you very frankly, we always know that where we stand. Maybe we are slightly over confident, but in reality, in our hearts, we know what we have done right, what we have done wrong. So this is again depends, how you are proceeding the case. Over.
Absolutely. So that's a very, very interesting point. We are, of course, we've graduated into the question and answers already, so we'll continue with that. But I just wanted to also mention that some of the points which have come about is that obviously there are cost factors, there's efficiency factors, there's expertise factors, because you also want to make sure that you actually pick up an arbitrator who is able to give you a fair consideration, a fair resolution. The small claims procedure, as a lot of both Prem and John have mentioned, is actually quite useful. It not only caps the arbitrator's fees, it caps the legal costs recoverable. It also reduces the time for the award to be given to 21 days after the submissions or the proceedings are closed. So obviously you have a lot of value that you can bring in, like the procedures in SCMA. Irrespective of that, you obviously also have a lot of other issues which come up from time to time. One interesting point which was raised by, he's not put his name, or she's not put her name, is one perceived disadvantage of arbitration, the lack of precedent creation, meaning that the same issue on the same charter party clause may need to be arbitrated again and again. So I presume that there is an ability to have arbitration awards redacted and published, and there is a regular set of arbitration awards which are published. What is the precedent aspect in this case, Prem and John? Would you as an arbitrator use one of those arbitration awards and be persuaded by that logic or that thing, or you really don't do that? In a case?
Let me put it this way, just as with the position of a high court judge, if he looks at another high court judge's decision, he's not bound by it. He's not bound by it. He can reach his own decisions and say, no, I choose not to follow. He is, of course, obliged to follow a decision of the Court of Appeal. So similarly, an arbitrator looking at another decision on
happens in most cases, would you be actually go through that
well,
route?
I hope that what happens in practice is that the arbitrator exercises his own independent mind and
Sure.
reaches his own decision.
Of course.
From my perspective, from a practitioner's perspective,
Mm.
if there is an arbitration award available on a point which you're seeking to look at on behalf of your client, then it is something which is a tool to use in order to give some guidance. There are a couple of issues with this, though. The first is that it takes quite a significant amount of effort to redact an arbitration award and publish it. And therefore, not all that many arbitration awards actually do get redacted and published. That's the first point. The second point is that, as Prem very rightly says, the arbitration award will not be binding on the arbitrator and might not even be all that persuasive. And I would generally find that it's useful in circumstances where it has been referred to somewhere else. So, for example, in academic writing, if somebody refers to an arbitration award and says, we think that the arbitrator's got it right in that instance, then I would feel a lot more assured in relying on that decision in front of an arbitrator later. The arbitrator still wouldn't be bound, but I would have two independent sources backing up that point, which would be the arbitration award and the academic writing.
Okay.
Following up on that point, it's quite an important point. There is an ongoing discussion in Singapore as to whether the courts should be hearing appeals from arbitration awards in order to develop the law as such. There is certainly a feeling in England that not enough arbitration awards are coming up, so that the law is not being developed in the areas where decisions are made by arbitrators and they're not challenged. The parties in Singapore will soon be given an option to opt in to an appeal procedure, by which they can then decide, should one of them lose, to bring it up on appeal. But for that, they will have to opt in. But it's also possible in their own arbitration agreement for them to decide at the outset that should there be an arbitration, and should one of them be dissatisfied with the award, that party has the option to go to the High Court to appeal against that award. That can be actually set out in the initial agreement.
So the parties have a lot of autonomy to
Absolutely, yes.
Prem is absolutely right, but my experience with commercial parties at the time when they enter into a contract is that at time of contracting, everybody is friends and everybody thinks everything will go swimmingly well and that they will have no need for their dispute resolution clause, and that if they do, then ultimately they will not want to spend lots of money on lawyers, and certainly not on carrying out the dispute resolution process twice or three times with appeals. So usually, if it's a question of opt-in or opt-out at the time of contracting, most commercial parties, and Jamie and Jaspreet can correct me if I'm wrong, would probably opt for finality and not for an appeal. Most lawyers would opt for an appeal because they want a second bite at the cherry, but I think commercial parties probably not so much.
Sure, that's a valid point. But it's a useful option to have, and also a useful awareness that parties are having that much of autonomy to decide on these things in their own agreement. And if both parties have decided, then accordingly it can be done, because that's a very common misconception which does exist with regard to Singapore arbitration. And that is good that you've resolved that, both Prem and John. So thank you for that. There are a couple of more questions before we go to the exit poll effectively. Is it a natural course to avoid arbitration due to time and cost? Is it a fair judgment? Is a fair judgment not possible in arbitration? I think you've answered some part of that question already about time and cost, but the fair judgment part, I mean, isn't it again coming back, Prem, a little bit to the choice of arbitrator, what kind of arbitrator we are looking at, and how is that process all about, basically?
I'm not sure I understand the point being made. Could you read that to me again?
Is it a natural course to avoid arbitration due to time and cost? Is a fair judgment not possible in arbitration? So I presume he wants to know whether the time and cost actually makes the judgment a bit unfair for the party who loses out, probably.
Well, that here again, I mean, there are so many ways you can answer that particular question. Time and costs will depend on the size and the complexity of your claim. As we have said earlier, if it's a claim that can come within the small claims procedure, there's really not that much time and cost involved in the first place.
Right.
But then, you if you're not careful and your claim's a fairly large claim, as we have said, you can lose sight of time and cost. That is where you need to choose your arbitrator carefully, and that's where the lawyers have to behave responsibly as well, in order to bring the matter to a quick conclusion. The tribunal does have a discretion to punish the parties, or each of the parties, even the successful party, with by depriving that party of time, some of that party's costs, which things should not have been incurred in the first place.
Absolutely.
I would just like to add, I agree with everything that Prem just said. I would just like to add that my experience of arbitration has been that sometimes there are results which you are not satisfied with, but I don't think I have ever experienced a result which is demonstrably unfair. And one of the good things I think about Singapore arbitration is that as long as you appoint arbitrators who are on the various panels, they are people of integrity who will give a fair result. And that is, I think, one of the things which is good about arbitration, particularly in Singapore, might not be said of every single jurisdiction.
Sure. Absolutely. Thank you. And obviously, I have another point as a rejoinder to the previous discussion we had on right of appeal. Joe and Matthew talks about appeal from arbitration may defeat the confidential nature, which is one reason why arbitration in the first place is PNC. Same when awards are published for sake of precedent. So obviously, that's a good point. At the same time, I've got Captain Rohit Bhatia kind of recapping a little bit and getting your views. I request each one of you to reconfirm this. So does the panel agree that in order of priority in business deals and contractual relationship, the following apply? Number one, personal relationship. Number two, a well-drafted charter party. Number three, good communication. Four, excellent skill sets. And finally, cheaper and efficient dispute resolution mechanism. So are these five aspects which will probably make parties to really keep the contractual relationships alive, but also make sure that they use the arbitration in a way of resolving disputes and moving on from there? I would say the just one point before you answer is this idea, and I've learned more about it after I joined SCMA, is that the dispute resolution clause or choice of dispute resolution mechanism as well as seat of arbitration is something that you need to decide much before the dispute actually happens. So it's very important that you choose wisely at an early stage as to which dispute resolution mechanism, which dispute resolution forum is more suitable for you. And then you can go into the actual aspects of using that dispute resolution seat or forum like SCMA, using a small claims procedure or the panel of arbitrators or even non-panel arbitrators. All those things come later. But the key is you need to agree the right clause at the right time. So is that something that is obviously very crucial to have that discussion? His first item on that list was a personal relationship. Is that the very first thing that will actually help you to move on and resolve this in an easier way as you go along? So all the panelists can answer that one. Yeah?
I think the personal relationship will, in instances of dispute resolution, will only hold as much weight as the amount of authority the person or the people have in trying to solve the problem. Quite often, it depends on the size of your business and the volumes of trades you're involved in. It could be very much the case that it's two relatively junior people on each side of the fence who have concluded the deal and drafted or negotiated the charter party. Skill sets aside, let's all assume that they all know what they're doing and have been well trained. But when it actually comes to signing off on something, if they don't have the authority to do so, the relationship, the personal relationship, is kind of moved off the table. Sure. I would say.
I would agree with Jamie, because you see, when we do our business, we start our business with a personal relationship. We just don't pick up anything and say, okay, I'm going to do with X, Y, Z. We see the background, we see who's behind it, what is the financial background, how the people are there, who's the person in charge for commercial side. That is the first step we do it. Second step, communication, yes. We are drafting agreement, everything is done, the skills are involved. But that does not mean there cannot be any dispute. Disputes are bound to happen. Now it depends how good is your relationship after having all these things executed. So this is a key point. It's not necessary that you have a personal relationship, everything will go smooth. I don't think on the MNCs, personal relationship does matter. But on the small houses, yes, maybe the person has a power. He said, okay, I take off 60%, you take 40%, we let it go. But in organized or big companies, definitely personal relationship come to some level. Yes, it is okay. But if it goes beyond that, then it's a legal matter. Over.
Sure.
I think what has been said by both Jamie and Jaspreet is effectively there comes a point when the dispute goes beyond the pay grade of the people with the personal relationship, and it's taken out of their hands. And at that point, it becomes important that if it's a dispute of the size where you require legal representation, that the legal representatives on each side are sensible and do their best to reach a resolution which is sensible between themselves as the matter progresses. Often the matter will, by the time it gets put in the hands of the legal representatives, be at a point where one or both parties want to go to arbitration at that point. And sometimes a certain amount of steps need to be taken before a settlement can be reached. But sensible legal representatives realize that they keep their clients by settling disputes and will do better by trying to find ways of resolving the dispute at every step.
Okay, that's a good one. Prem, do you have any thoughts on this from your side?
All those factors are obviously relevant.
Sure.
Not in any particular order, but cumulatively, yes, all of them do matter. Yes.
Great. Thank you. So if I can just quickly summarize before we go to the poll and the concluding remarks. Really, what I have picked up is, first of all, the parties have a lot of authority and leeway and autonomy to manage the process themselves. Things like ability to right to appeal, the ability to choose the arbitrators. Obviously, the parties have a lot to do during the commercial negotiations, post the commercial negotiations, during a dispute resolution aspect. It's really the parties who have the upper hand in that sense, and that needs to be kept in mind. The other aspect is, of course, the fact that SCMA offers a solution in terms of getting the parties to do a cost-efficient and a quick arbitration, especially the specialized procedures like small claims and CDOC, as John mentioned. These are all things which have hopefully get people to realize that if a dispute has occurred and both of them are not in a position to resolve it, it is not a bad thing to go and ask an expert whom they can choose together to actually go ahead and resolve their problem. So this hopefully is kind of the direction that we are taking as such. So on that basis, if we take this forward, and I can request Winnie to just quickly have the poll now with exactly the same question that was asked at the beginning.
Before you
Go
go
ahead.
into the poll, Puneet, can I just add one point? It's also possible to have an SCMA arbitration using a ARB procedure.
Very true. Very true.
Meaning you start off by appointing an arbitrator, but then after the appointment and the notice of arbitration, the parties can then start to mediate the dispute. And if that mediation doesn't work and the dispute is not settled, that arbitrator then can continue to wear his other hat and proceed with the arbitration and render an award. So it is possible to remain friends.
I have to say I'm very keen on that style of procedure.
Yeah.
Same actually.
Yeah.
I mean that goes right back to what we were saying at the very beginning about using arbitration, if you like, as a tool, you know, to not necessarily gain leverage, but to get people to the table to talk, which is quite often the problem, is not being able to get the other party to communicate with you. If arbitration becomes time efficient, cost effective, then the other party knows you're not going to bluff by saying, right, if you don't answer me, we're going to arbitration, because it is a very real outcome. And if once you then get the party to the table, you can then get to a mediation point, which is what you'd hope to achieve before even going to arbitration, you've achieved the same net result. So I think it's a great avenue to pursue.
I thought I'd put in that point before your poll is taken.
One thing which I would like to add, sorry, the discussion's been very interesting from my perspective. I've enjoyed it a lot. One thing which I would like to add is that quite often when I suggest mediation to my clients, they might say, isn't it a sign of weakness if I mediate now? And I think that if there is an ARB-Med-ARB procedure that you are following that is specified, then you don't have that problem. And there is no, I'm showing weakness by mediating here in that situation. Sorry, that's...
Absolutely. And that's a very valid point. And thank you so much for bringing that up. So the poll is now in play. We have the exactly same thing. After listening to these things, do you actually feel that commencing arbitration against your counterparty will adversely affect your business relationship? So hopefully we will get more people turning towards trying to use arbitration as a way of resolving, closing disputes and moving on into business.
Is that arbitration in its current guise, or a new improved, super streamlined, cost-effective?
The new improved version. So
the new improved version, okay.
We will see that going. So it seems we have got 104 people polling now, and that's obviously closed now. I think we can end the polling. It's 49% believe, 48% actually believe that it will not affect adversely your business relationship. So it seems that we have managed to convince a sizable amount of people, at least the majority is now shifted to the other side of the fence, which is a real education for me as well. I think we are, at the end of the day, in SCMA, also a part of the global maritime arbitration landscape. And if anything that benefits the arbitration as a whole, eventually benefits the entire ecosystem. So I'm really, really happy that we get a chance to do this. And I'm very happy that we actually get a chance to discuss these things, which are very, very close to what we want to try and do. We are constantly improving, and we would love to see your feedback on any future topics that you would like to talk about or bring us we can bring to you. In the chat box, you can actually put in any subject topics, because that will get saved in the webinar. So please do put any topics that you may want to actually want SCMA to hold future webinars on. This is obviously with COVID-19 a trend which will continue for some time. But that's the way we stand at the moment. All that remains is for me to thank all the panelists and all the attendees for coming in. Captain Dutt, thank you so much. This was a pleasure to have it with ICS, and I'm sure future events will also occur where ICS and SCMA can collaborate. So thank you very much for that. And thank you so much for all the panelists. It was a completely well-rounded view from all various corners that I really liked to hear. And I myself have learned more things as I go along. So appreciate your time and your support. Thank you very much, and have a good day.
Thank you, Puneet. Thanks, panelists.
Thank you.
Thank you. Bye-bye.
Bye-bye.